We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. I have several immediate warnings I want to give you that will protect you from what's to come. The first warning is a concept called the pretext phone call. The pretext phone call is when the police have a child or a relative of the child place a phone call to you. The theory behind it is that the police want to get to you while your guard is down and get you to confess to something. While the phone call is being made, it's normal practice for the police to be sitting there feeding questions written down on pieces of paper to the individual who placed the phone call. The concept is okay, and it is legal. However, it is misused. Think about getting a phone call from somebody that says, "You abused me. If you say you're sorry, I won't go to the police." Well, that puts enormous pressure on somebody who's innocent to say, "I'm sorry." In that way, it's over, and they don't have the police involved. However, when those words, quote, "I'm sorry," close quote, are later played back to a jury, it's going to sound like, "I'm guilty." What we recommend is that if you get one of these calls, just say no, nothing happened, and hang up. You do not want to spar with the cops that are on the other end of that phone call. Stay away from it and immediately call us. The second warning is that at any time you're going to be subject to a search and seizure. A warrant may be issued and your house searched, your car searched, and your computer searched. If this should happen, do not interfere with the police officers. You do not want charges of obstructing a police officer to complicate this matter. The third warning has to do with talking to the police. Most people believe that if you don't talk to the police will think you're guilty. Well, it doesn't matter what they think. What matters is the evidence. The police have been trained in a process called the Reed method of interrogation. Now, you haven't heard about that before, but let me tell you this. Back in the 1930s and 40s, the police could beat you with a rubber hose to get a confession. The Reed method of interrogation is a psychological rubber hose. You can be beaten with that psychological rubber hose, and I guarantee you that you'll confess to killing your mother, even if she's still alive. It's that powerful. That is why we tell people, do not be interviewed. Do not be subjected to an interrogation. Ask for an attorney. Assert your rights to remain silent. You should do that whether you're guilty or innocent. What comes out of those interrogations can hurt you even when you're innocent. I want to explain to you what we call the three-ring circus. Sometimes false allegation cases have to be defended in several different areas. That is why we call it the three-ring circus. In addition to defending yourself in criminal court, in some cases, a spouse will begin a divorce case at the same time. Divorces are considered civil and are litigated in the family court. In addition to your criminal defense, the state may file a petition to stop you from having contact with your children. This may be litigated in the juvenile court. Also, if you're a licensed professional, like a physician, a dentist, a nurse, a psychologist, or a therapist, the state may also file against you in the state's licensing administrative court. You can see why we call this the three-ring circus. Sometimes there's even a fourth or even a fifth ring in the circus. And you must remember, in some states, the government may seek to have charges filed against you in a criminal court, the juvenile court, and in licensed administrative courts, all at the same time. In our experience, this teaches us that the prosecutor's office will do just about anything to pressure you to settle for a felony prison term. Obviously, few of us have the funds to fight all of these battles at the same time. That is why these tactics by the prosecution are so effective in compelling the defendant to make some kind of plea bargain to end the suffering. We recommend damage control, or what our emergency room colleagues might call triage. This means that you must pick the battle that is most important and put all of your resources into that fight. We believe that this is always the criminal court. Why? Because you cannot visit your children from a prison cell. You cannot enjoy your marriage from a prison cell. You cannot practice your profession from a prison cell. At the same time, we believe that you must use a defense team that is completely aware of what the standards are in the family law court, the juvenile court, and the state's administrative court, and is able to assist you in those courts also. It is important to make sure that whatever is done in any of these other courts does not hurt your criminal case, and vice versa. This is just another reason why we have experts in our group in the area of family law, juvenile law, and state administrative hearings. For decades, the crime of rape has been known as the easiest criminal accusation to make by the alleged victim and the hardest to disprove by the defendant. In the 1960s, the victims of this brutal crime were able to take advantage of significant changes in the law that made it easier to obtain convictions and justice. Unfortunately, these changes also made it easier for those who were falsely accused of rape to be convicted as well. Adding to the defendant's difficulty is the controversial rape trauma syndrome, a psychological theory that has been rejected by behavioral scientists. Unfortunately, this idea is still being used by prosecutors and junk science witnesses as so-called evidence in cases against the defendant accused of the crime of rape. A series of biased laws are making it easier to obtain convictions. First, jury instructions are the law that is read to the courts. Courts have known that rape is the easiest allegation to make, but one that is hard to disprove. In fact, the biggest threat of being falsely accused of a crime was that of being accused of rape, until child molestation became a significant national issue, flooding the legal system with those types of cases. It is now the most likely false allegations. Courts perceived the potential threat of false allegations of rape and fashioned jury instructions to inform members of the jury that such allegations were easy to be made but difficult to disprove. Today, in most states, this jury instruction is no longer allowed to be given as a result of changes in the law. Changes that also mandate giving a very different set of jury instructions. In many states, the judge now informs the jury that 1, an allegation of rape does not require any evidence of corroboration. 2, there is no requirement for medical evidence. 3, there is no requirement for DNA evidence. 4, there is no requirement for a second witness. In short, the only requirement for a conviction is the bare allegation made by a complainant. Even the manner in which the jury is selected is tainted with this attitude that evidence doesn't matter. In many states, prosecutors can demand that during jury selection, each prospective juror must agree that he would not require corroboration of a crime. If the juror disagrees with this demand, he or she can be excused for cause. We then have the rape shield laws. By the way, consensual sex is still legal. Being able to prove consent, however, becomes much more difficult for the defendant. For example, if a man meets a woman at a bar and has sex with her that night, and later she claims she was raped, the man used to be able to introduce evidence to help establish a pattern of consensual sex on the part of the woman. That might be the testimony by witnesses that a woman routinely came to the bar every night, engaged a man's companionship, and went home and had sexual relationships with him. Such evidence is relevant to show the sex on the night in question is consensual, but now it's not admissible. Victims' rights advocates were rightly concerned with the legal strategies that put the victim's personal life on trial. Unfortunately, highly relevant evidence that could have protected an innocent defendant is no longer allowed because politics has obscured justice and powerful lobbies have helped to pass what is now called the rape shield laws. Under those rape shield laws, a defendant in today's courtroom is forbidden from introducing the prior sexual conduct of the complainant on the issue of consent. Curiously, no one has successfully shown that the evidence of prior sexual conduct is not relevant in determining consent. While the rape shield laws were intended to encourage more women to come forward and testify, it simply has made it easier to falsely accuse and convict an innocent individual. Many states also allow the prosecution to introduce allegations made by other women allegedly assaulted on previous occasions by the defendant to prove that a rape occurred in the current charged offense. It doesn't matter even if those allegations are 30 years old. In these circumstances, no corroborating evidence is required to introduce these old allegations. There does not even have to be a conviction, nor does there even have to exist a criminal charge or even a police report. The uncorroborated word of a single individual is sufficient. As you see, many state legislators are creating new victims by keeping out the sexual history of the complainant on the issue of consent, but allowing into evidence remote sexual history or allegations of sexual history of the defendant. This is sheer politics and not based upon relevancy or fair play. This kind of legislation is systematically making it easier to obtain convictions. While those guilty of rape should be convicted, those who are falsely accused should be allowed to defend themselves adequately in court. Now, let's look at rape trauma syndrome. The members of the jury are the triers of fact. They hear the account of the complainant, and if the defendant elects to testify, they hear the testimony of the defendant. This is the classic he said, she said situation in which jury members must decide who is telling the truth. In an attempt to provide greater credibility to the complainant, and thereby tip the scales of justice in favor of conviction, Ann Burgess and Lynn Holstrom wrote a psychological description of what they called the rape trauma syndrome. This was written in 1974. A true syndrome is a constellation of symptoms that, when presented by an individual, leads to a diagnosis of an illness. Rape is not an illness. Rape is not a diagnosis. First of all, the rape trauma syndrome is not really a syndrome because no diagnosis can be made from the syndrome. Secondly, there was no scientifically controlled study done by behavioral science professionals that support the theory of rape trauma syndrome. The fact is that this highly questionable theory is not recognized in DSM-4. DSM-4 is the Diagnostic and Statistical Manual of the American Psychiatric Association, and it is the current group of recognized diagnoses by behavioral science professionals. It includes all the current recognized diagnoses and recognized syndromes. Rape trauma syndrome is not in the DSM-4 because it was rejected by the behavioral science community, psychiatrists, psychologists, clinical social workers, and others. One reason rape trauma syndrome is unscientific is that Burgess and Holstrom assumed that any allegation of rape was true, and on that foundation devised an explanation for whatever the alleged victim might say or do. It seems their rape trauma explanation does not constitute a description of symptoms of an illness, but rather a way of manipulating evidence in favor of the complainant. For example, if a woman recants her story and admits that she was not raped and that she lied, the prosecution can put on a supposed rape trauma expert on the stand to testify that this behavior of recanting is consistent with being raped. The implication is that the original rape story should be believed and the admission of lying should not. This demonstrates why we refer to rape trauma syndrome as a confirmatory bias-based description. Believe the woman if she says she was raped, don't believe her if she says she was not raped. What is meant is that the syndrome demonstrates a built-in bias towards confirming that a rape happened. In a process like this, all symptoms lead to the conclusion that it happens, and this is consistent with a prosecution expert using a confirmatory bias model. Our office has never witnessed a so-called rape trauma expert testify that the complainant's behavior is also consistent with false allegations of rape. This is true even though it is widely known and accepted by legitimate researchers in the behavioral sciences. Other descriptions found in the rape trauma syndrome explain that if a woman immediately reports such action, that is consistent with the typical reaction of a rape victim. Curiously, this same so-called syndrome explains that if a woman waits for years to report, that is also consistent with the typical reaction of a rape victim. The rape trauma syndrome folks also explain that if a woman is flirtatious, such behavior is consistent with the typical reaction of a rape victim. But if the woman is withdrawn and not flirtatious, that too is consistent with the typical reaction of a rape victim. Should the woman cry when testifying? That's consistent with the reaction of a rape victim. But if the woman doesn't cry, that is also consistent with the typical reaction of a rape victim. The list of descriptions covers almost every conceivable human behavior that a human being might have over the course of a lifetime. As you can see, this makes any behavioral evidence support the charge of an alleged victim. Burgess and Holstrom's assumption that all allegations are true is not only unscientific, it is dangerous. Such thinking is also contrary to the U.S. constitutional principle that a person is innocent until proven guilty beyond a reasonable doubt. Rape trauma syndrome is not science, but unfortunately the courts in many states have given it legitimacy by allowing the testimony of supposed experts to be heard and by allowing the prosecution to misuse the word syndrome. Can you imagine the reaction if we went in with fake rape trauma syndrome? they would laugh. This pseudoscience makes it easier to mislead the jury in order to obtain convictions, not just of those who are guilty, but those that are falsely accused as well. Let's talk for a minute about defenses. When an individual is falsely accused of rape, the defenses fall into three basic categories. Number one, the defendant did not have sex with the complainant. This means either that the complainant was lying about having sex or the complainant has misidentified her assailant. Two, the defendant had sex with the complainant, but the sex was actually consensual. And the third defense is that the defendant had sex with the complainant and the defendant had a good faith belief that the complainant consented, whether or not there was actual consent. Because the crime of rape has become a political hot-button issue, many state legislatures have passed laws that make it more difficult for anyone falsely accused of rape to introduce evidence on any of these three defenses. Being concerned with the rights of someone falsely accused of this terrible crime doesn't make politicians popular in the polls. That is why the fate of the falsely accused rests in the trial skills of the defense team to overcome this biased system. What about sentencing? There is only one thing worse than being falsely accused of rape, and that's being falsely convicted of rape. As a convicted rapist, a person falsely convicted faces registration as a sex offender for the rest of his life. In many states, the sentencing laws have become more restrictive and severe. For example, in California, the law used to state that the defendant could be sentenced up to 8 years on one count of rape, with 2 years for each subsequent count. That law was changed to punish the convicted individual with an 8-year sentence for each count, and all counts to be served consecutively. In other words, 2 counts of rape can be punished with 16 years of imprisonment instead of 8 plus 2 years add-on for a total of 10 years. More disturbing is the prosecutor's ability to turn a single alleged rape into numerous counts because different sexual acts allegedly occurred during one encounter, which now can be filed as separate crimes. For example, the falsely convicted can be sentenced to 8 years for intercourse, 8 years for rape with a foreign object, in other words, finger insertion, 8 years for sodomy, if the jury finds the defendant guilty. If the complainant alleges that the accused stopped the rape and then a few seconds later started over, each new act becomes an additional count. Extreme sentences of over 30 years up to hundreds of years have become commonplace as a result of this charging scheme. Finally, someone convicted of this crime was once given a 50% credit, half off of his sentence, for good behavior and doing his job in prison. Many states have now reduced credits for good behavior and work time, and California now gives only 15% credit. Think about that. That's the equivalent of increasing actual sentences by 70% just by changing the method by which good time, work time credit is calculated. Well, where does this leave us? Because of the nature of the crime and the victims who felt that they had not obtained justice, the rape complainant has an army of lobbyists pressuring different state legislatures to pass laws that favor the alleged victim at the expense of the defendant's right to defend himself. Those who are falsely accused rarely have representation when new laws are being proposed. Even if the falsely accused do have a few lay spokesmen attempting to educate their state legislator, the typical politician does not want to become involved on such an explosive issue. There are few people in office willing to risk a political career for a few people who have been falsely accused of rape. The only way to overcome judicial and legal inequity is through a thorough professional investigation and with evidence presented by a highly skilled defense team. It is a matter of educating the jurors so that they can make an informed decision about what is and what is not a true allegation of rape. We get numerous telephone calls wanting to know whether or not we recommend taking a police polygraph when the police call and offer you one. We believe that police polygraph examinations are not reliable. We don't need to get into the scientific discussion as to the reliability when an example will suffice. We have had clients that have taken 2 polygraph examinations. Our examiner is the individual who trained police officers throughout his career at the California Department of Justice and later retired. He now does private polygraph examinations. We have had cases where our examiner has passed the person and found them to be not deceptive, while the police department examiner, who is trained by our examiner, found them to be deceptive. Why? We have also seen certain police examiners that never find that anyone passes a polygraph. They always find that the suspect is deceptive. Further, many prosecutors are not moved by a favorable result on a polygraph machine. They only believe the results if they point towards guilty. Why? Well, they have explained it to us that psychopaths have no conscience and therefore demonstrate no stress when they're lying. They believe that a pedophile is a psychopath who can pass a polygraph. If the suspect flunks, they believe the result. If the suspect passes, they don't believe the result. However, nothing is absolute, and on a few occasions we have had cases dismissed upon polygraph examinations. With some lawyers, if the client takes a polygraph and fails it, there is a tendency to stop preparing the case because of the belief that the client is guilty and the case should be plea bargained. At the very least, the attorney does not have the zeal that he or she might otherwise have had. Further, the client may become afraid that the attorney doesn't believe in the case and will not try as hard. There is a breakdown of trust in the attorney-client relationship. With police examinations, too often the polygraph examination becomes a ploy used as part of the interrogation process. This is how they are trained. It is the questioning of the client before, during, and particularly after the polygraph examination that they want. Even if the person passes or it's inconclusive, the officers are allowed to lie. They can tell the suspect that they failed the polygraph examination and then ask the suspect what could have happened that would have caused that. Maybe you accidentally touched her, something to that effect. The polygraph examination is literally used as a psychological ploy to apply pressure to extract some sort of an admission. We would recommend that you not take a police polygraph examination. If you want to have a polygraph examination, you should go to a private, reputable polygraph expert. I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke, and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity we bring to continuing litigation. It is also an example of why you cannot evaluate a case until it is completely prepared, until you have all of the answers. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop, which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. Remember, there is hope. Many clients ask about coverage in their area of California. Simply put, we handle cases all over California. Our team members appear in every California county and have done so for years. We keep connected to our office electronically over the internet through PC Anywhere and other computer programs. It's easy to get around the state of California. With the use of Southwest Airlines and United Airlines, we are linked to all of California. Besides being linked to our own data files and research, our experts, our investigators, and all members of our team are also connected over the internet. This allows our team members to have instant access to all the materials that they need, no matter where they appear in the state of California. Sometimes people will say, well, gee, there's an attorney here locally who says he knows the judge, wink, wink. Well, I've never seen a judge or a DA give away the case because of friendship. But what I have seen over and over again is that when we appear in the courts, we're prepared, we have our investigations done, we have our motions done, and we know what we're doing. Within the first day, the judges have gotten to like us because they recognize quality presentations, and that's what they're interested in. And that is what they're interested in. We know that you are located in another state. You need to know if our team can come into your state and represent you. Of course we can. Our team members practice in every state on a case-by-case basis. This is a procedure called pro hac vice. This means that an out-of-state attorney presents his or her credentials to the local trial judge and requests to be allowed to practice just like a local attorney in your area for just your case. In fact, the U.S. Supreme Court has encouraged this practice. Why? So that people can get an expert in the field that they need, because many times these experts are not available locally. When we practice outside of California, we always work with a local attorney. This helps us to make sure that all local rules for your state and your county are followed. We have in our office the law of all 50 states, federal and military, so we are able to represent you in any of these forums. Now that you know the politics and seriousness of the offense that you are accused of, we would like to meet with you. We will try to stop the charges from being filed, if they have not already been filed, by contacting the police and the district attorney. Maybe, if they are presented another side of the case, they won't even file. We will protect the evidence for your defense. This must be done immediately. Before you meet with us, it would be important that you prepare a chronology of events and set out everything that has happened and the time order in which it happened. Clearly mark that attorney-client privilege at the top of the document so that if it is intercepted in any way, it is protected. We also need to know about your background and any prior allegations that have been made against you. You can survive these charges. We believe that the survival is based upon preparation, preparation, preparation. Defending against allegations of this type can be costly. However, you only get one trial. You only get one chance. We cannot guarantee the outcome. Those attorneys who do that are lying to you. What we can do is make sure that everything that can be done will be done. In this way, we maximize your chances of the best outcome in your case. Dr. Larondos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion. Cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences, and he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these two books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. We're known for being a big case firm. We don't go to court with 10 files under our arms, as you'll see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There's a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened